Hello, my name is Sam McClure, founder of the adoption law firm. Today I want to discuss a recent case from the Alabama Court of Civil Appeals, ACB versus JEB. It was released on October 21st, 22nd of 2022. This case dealt with two children who were in the home of the aunt and the uncle. And the aunt and the uncle, after several years of these children being in their home, sought to adopt these children. The natural father was deceased through an automobile accident, and the natural mother had consistent struggles with drug addiction. Early on, when the children were in the aunt and the uncle's home, probably for the first 2 years, the natural mother really struggled with the drug addiction. She struggled to maintain any contact whatsoever with the children. She provided no financial support. In the few months, 6 months leading up to the trial, the natural mother had made some progress and improvement. So the case centered around, at least in the trial court, centered around whether or not the natural mother had given implied consent to adoption. Now, there's two kinds of consent. Anywhere in the world where an adoption takes place, the consent of the natural parents is required. And so express consent would be signing your name on an affidavit. Implied consent can be found with things like abandonment, or here, and most litigated, 6 months of failure to maintain a significant parental relationship. Now, that significant parental relationship is measured by communication and support. So in Alabama, any 6-month period where a natural parent fails to maintain significant parental relationship through supporting the children, sending birthday cards, sending gifts, and communicating, phone calls, letters, visits, if there's been a 6-month period, the court should find that the parent has given implied consent. Now, here's probably one of the most interesting things about this ACB case is that the court, for the first time, we have case law saying that implied consent is irrevocable. Now, the statutes have said that for years. It's just the first time the Court of Civil Appeals has said, yep, that's what the statute says, and that's what it means. In ACB, the mother, again, had made some progress, yet the trial court said, we find that the adoption is in the children's best interest due to their bond with the adoptive family, due to the mother's lack of interest and concern, and the mother's given implied consent. Therefore, the trial court granted the adoption. Now, on appeal, the decision was written by presiding Judge Thompson. Again, a copy of that is in the description and in the links. I encourage you to go look at it if you're interested and read more. But for now, I think the most important takeaway for this new ACB case is that we have the Court of Civil Appeals supporting the idea that implied consent, once given, is irrevocable. This is a great case for adopted families and for children who are seeking permanency and stability. Anytime a natural family breaks down, whether it's death, abandonment, neglect, abuse, it's tragic. But adoption can provide that healing, permanency, and stability that children need. And at the adoption law firm, that's our mission.